Ladies and gentlemen, welcome back to another What If video. My name is Viepia, and as always, it is great to have you. Today's topic is what if a political party becomes involved in employment matters? Recently, we have seen many of our clients being confronted with a situation where a political party becomes, or at least attempts to become involved in the workplace. As we know, in terms of the Labour Relations Act, it's the role of the trade unions to represent members in the workplace. But the question is, can this role also be extended to political parties? Now, the matter I want to discuss is the matter between Calvin Lounge and the National Union of Furniture and Allied Workers Union of South Africa and others. Now, in this matter, there were representatives of a political party that informed the employer that they had been mandated to intervene on behalf of the employees and that a barrage of demands and grievances would follow in due course. Now, in this specific workplace of this employer, the workplace was in fact organized with a majority representative trade union being there, which the employer has established a collective bargaining relationship with. The next day, the political party arrived at the employer's premises and they presented a memorandum to the CEO of the employer on the political party's letterhead. Now, this memorandum stated that the political party would unashamedly take up the plight of the employees who were allegedly suffering an injustice at the employer's workplace. The political party accused the union of collaborating with the employer to advance the employer's interests to the detriment of employees it was required to protect. The memorandum also recorded a number of actual demands, and the employer was given 7 days to comply, with a warning that defiance of this memorandum would result in intensifying mass protest action. In response, the employer undertook to investigate the serious allegations contained in the memorandum, but drew the political party's attention to the fact that there was a majority recognized trade union with whom workplace disputes were effectively resolved. The political party, as expected, was not satisfied with this response or the accommodation of demands it had made, and it then resulted in a series of unprotected strikes. The company, as we would expect, approached the Labour Court and sought an interdict, which was at the end was granted, declaring the strikes unprotected and unlawful. But it's important to unpack just briefly what the court said. Now, the court began its analysis by asking what the political party was doing getting involved in workplace issues, particularly since there was a recognized trade union. The court then held that the answer to that was simply that the political party had no business in doing so, as it was not a registered trade union. The court held, and this is quite important, that the Labour Relations Act was specifically designed to designate the task of dealing with workplace disputes and grievances to employers' organizations, trade unions, and workplace forums, and that within that structure there is no place for a political party. As recent as last week, some of you might have read the articles. The Labour Court in Johannesburg heard another matter involving a political party that involved itself in workplace matters. And the court in that matter again confirmed that the political party had no business in doing so. So, ladies and gentlemen, in conclusion, what is not in doubt is that the legislative framework regulating the interactions between employers, employees, and trade unions does not recognize the right of a political party to intervene in these processes and seek to represent the employees. Now that then brings us to the end of this video. Thank you for watching, and as always, if you have any questions in this regard, please do not hesitate to contact us. Until next time, bye-bye.